Now, the Supreme Court, in a 7-member panel, has unanimously thrown out the interlocutory injunction on the implementation of the E-Levy filed by 3 members of parliament from the minority. It has, however, ordered the Ghana Revenue Authority to keep accurate records of the E-Levy transactions. The court cited a possible hardship on the economy if the injunction is granted. Samuel Mbura was there at the court and files this report.
The Supreme Court, in its ruling, raised issues of the nature of the reliefs sought by the applicants, Harun Idrisu and 2 others in the substantive matter, the inconvenience or loss to be suffered, including refunding the numerous tax deductions. The court speaks about the nature of the law under attack, the public interest and welfare of Ghanaians, the legal principle of presumption and regularity as enacted in the evidence decree. The court said the Republic would suffer a great deal if the government is temporarily stopped from deducting the levy from electronic transactions, and noted that mechanisms do exist within the current tax regime to refund payees who have either overpaid or wrongfully paid, and that must be taken advantage of. The court said while GRA can do a refund should the substantive case be won, the GRA cannot recover the levy if the substantive case is lost. In our opinion, greater hardship will be on the state, and the balance of power tilts in favor of the state. We order the GRA to keep accurate records of the amounts deducted so that at the end of the substantive matter, nobody will be disadvantaged. Addressing the media after the court proceedings, Minority Leader Harun Idrisu told the media after the court proceedings that they were satisfied with the performance of their lawyers. He indicated that the directive to the GRA to preserve the transaction record was in the right direction.
We remain determined that even on the balance of weighing monetary considerations against the weight of a constitutional breach, the emphasis should be on what harm we are doing to the 1992 Constitution and the 3 co-equal organs of states. So in the determination of whether some irreparable damage or hardship will be caused, our hardship as we understand it is the disrespect to the Constitution by the action of passage into law of an Act 1075 with numbers below the minimum constitutional threshold of 138 members of parliament. Can you imagine? I heard the Attorney General laboriously arguing that it was a voice vote. So Ebenezer Kum voted with his voice from an ambulance, or he voted with his voice from a clinic to add to the voice vote, and he is insisting that 266 members of parliament participated in the decision and participated in the motion. 266 members of parliament after the minority of 136 walked out. Certainly, these are matters that the Ghanaian public can judge better. But what is refreshing and heartwarming today is the second part of the ruling, which gives directives to the Ghana Revenue Authority to preserve and keep the money. At least some people will not be in a rush to collateralize it until the substantive matter is determined.
But the Attorney General, Godfred Dami, said the court's decision confirms his argument that the application was factually uncertain.
You saw what happened in court today. It was an embarrassing spectacle. The lawyer clearly was not able to demonstrate any form of irregularity with proceedings in Parliament. The court asked him, so is there any record that indicates that X number of MPs worked out at a certain stage? Is there any record that shows that a head count of all the MPs in Parliament was taken? That was not done. He said, absolutely said no. There was no evidence indicating whether there was a head count of the number of MPs present in Parliament who voted to support the bill. There's also nothing provided by the lawyer that indicated that there was a walkout by X number of people in Parliament. So I think we should ignore all that propaganda